Hey everybody, welcome back. This video is all about civil liberties, so let's get right to it. Alright everybody, this is my favorite section in all of AP Gov. You know, a wise punk band once said, "Know your rights," and I think that's a pretty good theme for this episode. So let's start by defining civil liberties. We're talking about individual, personal freedoms. These are often described as freedoms too. So we're thinking of free speech, freedom of religion, the right to bear arms, things that we should recognize from the Bill of Rights. And speaking of, just a reminder that the Bill of Rights protects individual personal liberty by limiting the federal government. So the Bill of Rights is all about protecting our civil liberties from an overly powerful federal government. Or at least that's what it did originally. But recently, and by recently I mean over the last 95 years or so, the Supreme Court has reinterpreted the Bill of Rights and decided that it not only restricts federal power, but also state power as well. Now that's a huge difference, that's a huge transformation of power, so let's talk about how that happened. We have to go to the 14th Amendment, specifically the Due Process Clause, which says, "Nor shall any state deprive any person of life, liberty, or property without due process of law." The first key word that we want to focus on is state. This amendment clearly restricts state power, unlike the original Bill of Rights, which limited federal power. In fact, what happens as a result of this is known as incorporation. So let's go ahead and define that first, and then we'll come back to the Due Process Clause. Incorporation is the application of the Bill of Rights to the states. Now, let's be very clear on what this means. This is a reduction in power for states. States will now be restricted from infringing on people's fundamental liberties, just like the federal government has been. Okay, so that's a seismic shift in the balance of power between states and the national government, and has huge implications for civil liberties. But let's go back to the Due Process Clause, because I didn't see the word incorporation there, or anything about applying the Bill of Rights to the states. So the other key word here is liberty. Now, it wasn't interpreted this way in 1868 when the 14th Amendment was ratified, but in a 1925 case, the Supreme Court decided that not only could states not take away your due process rights, but that the 14th Amendment also prevents states from depriving a person of their liberty. And in that particular case, this meant that states could no longer take away a person's freedom of speech. And this leads us to another important part of incorporation, and that is that it's been done on a case-by-case basis, selectively. Now, as of 2021, nearly the entire Bill of Rights has been incorporated, but there's still a couple things that haven't been yet. Now, for basically the rest of this video, we're going to go through different parts of the Bill of Rights, and we're going to talk about how they've been interpreted and sometimes reinterpreted. So why don't we start with the First Amendment? Seems like a logical place to start. So let's begin with freedom of religion. We need to break freedom of religion into two distinct parts: the Establishment Clause and the Free Exercise Clause. The Establishment Clause is the first part of the sentence. Congress shall make no law respecting an establishment of religion. Now, this has been interpreted as prohibiting governments from establishing an official religion, or usually more relevantly, giving preferential treatment for a religion. Governments can neither promote nor inhibit a religion. Policies must be religiously neutral. Your required case, Engel v. Vitale, is an Establishment Clause case that overturned a state policy that allowed for a voluntary prayer to be recited in public schools, with the court holding that such a policy constituted government endorsement of religion. Back to the First Amendment, the next part of the sentence says, "or prohibiting the free exercise thereof." This is the Free Exercise Clause, which guarantees to all citizens the right to practice the religion of her or his choice. The required case for the Free Exercise Clause is Wisconsin v. Yoder, which held that compelling Amish students to attend public schools beyond 8th grade violates the Free Exercise Clause. The First Amendment also states that Congress shall make no law abridging the freedom of speech. Well, they definitely do that sometimes, so I guess the real question here is, where's the line? The court typically rules in favor of freedom of speech because it's viewed as the most fundamental of all of our freedoms. But as with all other rights, the court does not hold that citizens enjoy an absolute or unlimited right, and therefore it can at times be limited. Even though the First Amendment definitely doesn't mention any kind of exception, but that's how the courts ruled on it. Your required case, Schenck v. U.S., provides us with a limit establishing the precedent that there can be time, place, and manner restrictions on speech. The idea is that there are forms of expression that are inappropriate at certain times or places, or could be expressed in an objectionable way, and therefore governments would be able to limit such expression by citing time, place, and manner concerns with speech. This obviously opens a Pandora's box trying to find where the line is, but currently the court has decided that speech can only be limited if it is intended to and likely to incite imminent lawless action. Other types of unprotected speech include libel, slander, and obscenity. On the other hand, symbolic speech and hate speech are protected forms of speech. Speaking of symbolic speech, our other landmark First Amendment case is Tinker versus Des Moines, which held that students have free speech at school. Even if it doesn't feel like it, the court promises that you have free speech. Additionally, the court said that symbolic speech is pure speech and therefore is constitutionally protected. Remember, this was the case where students were wearing black armbands to protest the Vietnam War, and the court determined that this is a protected form of expression. The court later built on this precedent and struck down laws prohibiting flag burning as an unconstitutional infringement on free speech. Closely related to free speech is freedom of the press, and your required case here is New York Times versus US. In this case, the court ruled against the Nixon administration's attempt to block publication of the Pentagon Papers by the New York Times and Washington Post, holding that because of the First Amendment's freedom of press, there is a heavy presumption against prior restraint or censorship. Turning our attention to the Second Amendment, this amendment has been the subject of some court cases recently, and in 2008, the court actually enshrined a new interpretation of the Second Amendment. In that 2008 case, the court established that there is an individual right to bear arms for the purpose of self-defense. There had been debate for generations over whether the Second Amendment's right to bear arms was connected to militia service, or rather it was a broadly held right of all citizens. This case answered that question in favor of the individual right. Just 2 years later, the court built on their decision in a 2010 case, McDonald v. Chicago, and this one is required for everybody. In this case, the Supreme Court invoked the individual right to bear arms once again, but this time applied it to state and local governments, thereby incorporating the individual right to bear arms. Okay, next is the Fourth Amendment, which protects people from unreasonable searches and seizures. Of course, what's reasonable or an unreasonable search has been the subject of much debate over the years. Recently, the Supreme Court has ruled that warrantless searches of cell phone data are unconstitutional. So they can't just look at the pictures on your phone or your texts or whatever without a warrant. And the court and Congress have placed limits on the bulk collection of telecommunications metadata. This is often referred to as mass surveillance, and in the aftermath of the Edward Snowden revelations, new limits were placed on the collection of this metadata, and there were rules put in place requiring agencies to get warrants to examine such metadata. According to the exclusionary rule, illegally obtained evidence cannot be used in a trial. The purpose of this rule is to protect individual rights, though some critics believe that its true effect is to make the job tougher for law enforcement. Speaking of the rights of the accused, one of your required cases, Gideon v. Wainwright, was a landmark ruling that incorporated the right to an attorney. The Sixth Amendment guarantees a right to a speedy and public trial with an impartial jury and legal counsel, and now, as a result of Gideon, states must provide an attorney to defendants who can't afford one. And as all fans of 21 Jump Street are undoubtedly familiar with, we also have the Miranda Rule, which requires police to inform suspects in custody of their Fifth and Sixth Amendment rights. It doesn't actually establish any new rights, it just says that suspects must be informed of their rights. There is an exception, however, and it's known as the public safety exception. If police ask a suspect a question to neutralize a dangerous situation, a statement made by a suspect can be used as evidence in court. And finally, we have to step outside of the Bill of Rights for the last civil liberty we're going to discuss, and that's the right of privacy. What's fascinating about the right of privacy is it's the right we all kind of assume and just like, yeah, of course we have a right to privacy, but it isn't actually enumerated anywhere in the Bill of Rights. The court discovered it in a 1965 case based on combining some of our other rights from the Bill of Rights, and they decided that this implied that there is a constitutional right of privacy. One reason this is so important is that the right of privacy is the basis for the holding in the last of our required cases in this section, Roe versus Wade. This case both established and incorporated a right to an abortion based on the right of privacy. This is a key example of the court as a policymaker because it prevented states or the federal government from passing laws banning abortion. For those of you following the news, this is a topic that is certainly getting a lot of attention these days in state legislatures. Alright, everybody, that's it for this episode on civil liberties. Make sure to pause the video so that you can answer these multiple choice questions. So go ahead, test yourself. See how well you know your rights. Put your answers in the comments below, and then the answer key is in the description, so make sure to check that out as well. Thanks for watching, and I'll see you in the civil rights video up next. Until next time, this has been a LaMoney production. Alright, thanks again for watching this video. Thanks for supporting my channel. Do me a huge favor and hit that like button. Make sure you subscribe if you haven't already. Tell your friends, tell your neighbors, tell everybody about this channel so they can do great on the AP exam as well. Be sure to check out the AP Gov Ultimate Review Packet if you have a minute. I'm sure that it'll help you. I have tons of great resources so that you can get an A in your class and a 5 on the AP exam. I'll see you guys in the next video.